We're excited to have Matt Grosh with us. Matt is with May Herr Grosh, and local attorney, estate planning attorney, does a lot of other things while he's there, but we're happy to have him here because lately we've been getting a lot of questions, Matt, about what do I do? So, and we'll kind of start off, I'll just kind of let you give a brief overview of how things work when you're seeing maybe a brand new client, and then I'll just kind of interject some other things that pop in as you're chatting.
Okay. Well, just to keep it basic, when you're talking about estate planning, you're talking about 3 documents per person, typically. The will, everybody knows what the will is, what happens when you die. But there are a couple documents that deal with while you're still alive. Some people, they go through a period of incapacity, sometimes a long period. So that's where powers of attorney and living wills come in. A power of attorney allows someone to basically stand in your shoes legally to make decisions for you while, if you're in a position where you can't, financial and medical decisions. And a living will comes into effect at the very, very end when a doctor determines that you're basically at the end of your life, permanently unconscious, incapacitated, and then says what your wishes are there. Typically, people want the no heroic measures. So usually at that point, things are limited to just easing your pain.
So we don't use a medical directive anymore, or a living will. How does that work?
That's just another name for it. You call them. Sometimes they're called advanced directives. Sometimes they're called medical directives. Living will. They're all basically the same thing.
Basically the same thing. Mm-hmm. And with the new digital, can people upload those in? Do you suggest they upload those into their medical vaults?
Certainly. Whatever you can put in and use technology to your advantage to send those documents. Certainly, your doctor's office should have copies of these things.
Okay. And then is it also true that lately they're doing more and more of these documents? I think some of them are pink, which kind of correlates to, no, don't put me on life support. And then when the EMT shows up, how's that what do you guys advise on that piece?
So what you're talking about is what's called a POLST. It's a Pennsylvania Order for Life-Sustaining Treatment. That's what that stands for. Mm-hmm. It's similar to a living will, except it goes into a bit more detail. Where a living will is a document created by your attorney or you, and you sign it and it expresses what your wishes are and who can make decisions for you at that end stage. A POLST is a little bit different in that it's an agreement between you and your doctor or the hospital that you're working with. So it's more of a medical document than a legal document. Not that it doesn't have legal effect, but that's what you're talking about there.
Okay. Now, one of the questions we get, Matt, is, hey, can I go on LegalZoom and do these things, or should I be seeing an attorney? What's the difference there? Because you made the comment, or you can make it. So I wasn't sure if you were referring to that.
Yeah, I mean, in Pennsylvania, technically, you can just scribble something on a paper, sign it, and date it, and theoretically, that's a will. Now, proving that that's a will is, lots of other problems, and you can avoid all that just by going to an attorney. Certainly, you have people who use LegalZoom. It's a service that's out there. As an attorney who gets paid to write wills, of course, I'm going to say you get what you pay for. LegalZoom, you would just check a couple boxes, and it, really, everyone's situation is unique, and estate planning attorney can work with you to kind of cater around all of your specific needs. And I've had clients, not just in estate planning, but in other areas, do the self-help of going to LegalZoom and then coming to me to undo the mess that they've made, and they pay me 3 times as much as what they would have paid if they just had come to see me in the first place.
So then each one's different. And I know we have some people that'll say, hey, I wrote my will, might have been 20 years ago. Do wills get outdated?
Well, they get outdated. They don't expire. There's no expiration date, but certainly they become outdated. Certain people you might have picked to serve as your executor pass away, or maybe you have a falling out with them, or things change, or you start having kids, things like that. So certainly wills can come out of date. My suggestion is when you have your estate planning documents in place, you should always review them. At least most attorneys will review, at least take a look and say, hey, are there any updates in the law, any updates in your life? Maybe every 5 to 10 years, I would say, is a good rule of thumb.
Or if something major happens, such as
having a kid, getting married, having someone in your family pass away. There are basically lots of big life changes. You win the lottery. There's a good reason to do it. So.
Okay, very good. So then, when they're doing these documents, we had a person ask us with the children. Many times, young couples we find it they struggle because they don't know who they want to be their guardian.
Right.
So Matt, how do you advise someone for that? What are some of the techniques you use in helping them to kind of narrow that down? Because I personally, again, it's a personal thought, should have a document in place.
Yes. Now, so I'm glad you brought that up, because one of the things that you can do through the will, and in fact, many young couples, the only reason they get a will really is because they can do this, is you can name guardians for your children if you and the other spouse passes away. As far as who to name, I mean, really, it really, I mean, this sounds simple, but you'd be amazed at how people mess this up. But just pick someone you really trust. You know, some people don't have a lot of people that they really trust, but you know, we can, you know, teach people some other things. Like we can, you know, if someone's not good with money, you figure, oh, they're not good with money. We can get them help with that. We can get them help with legal advice and things like that. But you can't teach someone to be trustworthy. They pretty much are or aren't. So that's you know, that's pretty much it. As far as leaving money to kids, obviously you don't want to leave you know, a big bank account to a 5-year-old. But there are trusts and guardianships that you can work with, and trusts are nice because you can tailor leave specific instructions for your trustee, you know, who takes care of the trust. You know, if you're to pass away, so that they can spend the money responsibly for the children.
Okay. Well, then that goes down to one of the questions we had. How much money do I need to have a trust? Or is it driven by what I own?
I don't know if there's a specific number, because again, it depends on the situation and it depends on what you want the trust to do. Trusts are one of those things that there's almost like a trust for every occasion. You know, there's tax planning trusts and special needs trusts, and but there's also trusts, like I said, to take care of your children until they turn a certain age, and then you know the money would go to them. There is no specific amount. Yeah, a trust can get to a point, like if you're talking about $500 per se, that's not going to last very long.
Right.
So I don't know. It just depends on the situation, but pretty much enough, I guess, depending on its purpose, that it'll at least last a couple years. You know, based on investing and spending and things like that.
Because we're seeing that the cost for just maintaining a trust is more and more expensive, or we're seeing financial institutions raise the minimums to some degree. So then it feels like it's almost too costly to have a trust. And that's where I was wondering if there's other tools that clients could use. Let's say their number is less than $500,000 for the child. And obviously, like you said, you don't want an 8-year-old to get $500,000. Right. So I'm sure there's some other ideas.
Well, first of all, one idea is when you talk about the expense, you're talking about naming a corporate trustee, like a bank to be the trustee of the trust. So if you name an individual, say your cousin or your sister or whatever, you don't have to worry about that. I mean, certainly they're entitled to be, you know, to some compensation, but it's not at the level that the banks are. Okay. I think they usually charge a minimum of 1% of the total trust, or $10,000 per year, whichever is less. It depends on the bank. They're all a little bit different. But some people have no choice than to use a bank. And in some cases, or if you have a contentious family and you think that some of the beneficiaries of the trust, I mean, everybody has those people in their family, are going to be trouble. It's the nice thing about a corporate fiduciary is you can say, hey, talk to the bank. I don't have anything to do with it. Okay. So, but as far as expense goes, you can keep the expense down by, if you have someone that you trust that can serve as the trustee, that helps. Because as far as having a trust, other than paying an attorney to set it up for you, to draft the trust agreement, setting it up, it's just like having another bank account. So it's really, the trust itself isn't that expensive. It's the fees on top of it.
Gotcha. Okay. Well, that should certainly make some people feel a little more comfortable.
Yes.
And then the minors. So again, don't name minors in a will is what I'm kind of hearing you say. Is that correct?
As far as naming executors, yeah, in order for someone to serve as your executor, they have to be 18 or older. So it's best not to name minors. I have some clients who they have a 17-year-old kid, and there they say, if so-and-so is 18 or older at the time of my death, you could do a provisional thing like that. But yeah, it's not a good idea. Usually, my experience with clients is they don't really name their kids to kind of step in and for them as the executor until their kids are in their early 30s at least, or maybe even late 20s. But
we hear that comment more and more. So what about charities? We have some people that say, should I put my charitable intent in the will, or should I put it like for instance, on a transfer on death agreement. So,
Well, it depends on what your purposes are.
Okay.
If your purposes are to get money out of your estate for federal estate tax purposes,
Mhm.
then you're looking at a potential charitable remainder trust, charitable lead trust. The purpose is you get money out of your estate at a discount because you're not giving the whole gift to a person or the charity right away. It's getting split up.
Gotcha.
And it's certainly the charitable distribution, charitable gifts are tax free if it's a pure charitable gift
Okay.
as far as the estate tax goes. If you're looking for to make gifting, what some people do is they'll have their estate and their will set up so that certain percentages go to certain family members, like their kids or whatever,
Mhm.
and then they might set aside 20% of it for a charitable beneficiary. And you certainly can do that in your will, but you can also do it during your lifetime as well. So
Okay.
you don't necessarily have to do it through your estate planning documents,
Mhm.
and you can just give directly also.
Correct. Or we even see it in IRAs.
Yeah.
Things of
Mhm.
that, or
Mhm.
life insurance beneficiaries, things of that type.
Correct. You can name
Okay.
charitable institutions in
Okay,
in
good.
those.
So, do you need an attorney to sell real estate?
No, you don't need an attorney to sell. In fact, most people really don't use
Okay.
an attorney. I mean, you think of a typical house transfer. Certainly, an attorney can help. And
Mhm.
if you have a difficult issue like conveying an easement or when you're not necessarily selling a plot, you're selling, an easement's just your ability to use someone else's
Right.
land. Then yeah, you probably will want the help of an attorney because
Gotcha.
you're probably crafting some. I don't know if you've ever seen a deed, but the legal definition of the land has starting at this point and 29 degrees. It's that really boring language,
Yeah.
but an attorney can help make sure that that's all correct,
Okay.
in coordination with the surveyor. But you don't need an attorney to sell real estate. It's a good idea to have someone who knows what they're doing
Correct.
because there are things that need to get done, like a seller's disclosure and things like
Okay.
that. So most people are comfortable with real estate agents.
Mhm.
If you're working with an auctioneer, however, like if you're selling a house through an auction, which some of my clients do, it's more common with estates because
Gotcha.
you're not really selling your own house. Usually, one of my jobs is to draft the conditions of sale. So you wouldn't need an attorney to help out in that area, but
Okay.
that's a very specific situation.
Yeah, for sure. What are some other things that you notice that you're kind of seeing a repetition? It's like, hey, you might want to just think about this. Is there anything that pops in your mind when I ask that question? Or
I guess the big thing, they changed the power of attorney law a couple of years ago, maybe 6 years ago or so. And the old powers of attorney are still enforceable, but some banks, we've talked about different banks, I
Correct.
won't name any,
No.
but some banks and financial institutions are more difficult in honoring powers of attorney, which can be troublesome because if you're incapacitated, you want whoever you name as your agent to be able to get as little pushback as possible when they're trying to sign checks for you, sign documents, basically do the things that an agent does in their duties. And we're finding that if you do update your power of attorney to the new form, that we're getting less pushback. We get
Okay.
pushback with some of the older forms, even though they're not really supposed to give us pushback.
I got you. Okay.
That's
So, am I hearing you say if I have my POA in place, it would be in my best interest, especially for the POA, for the agent, if I would just take the next step and maybe get that on the bank account or get that on the investment accounts?
Well, yeah. What you can do is stay a step ahead and get that to whatever finance institutions you're dealing with, your financial advisors. That way, if you're going to get pushback, now. Like they'll tell you,
Gotcha.
hey, we need you to fill.
Correct.
Technically, they're not supposed to. In Pennsylvania, they're not supposed to ask you to sign extra forms, but it happens all the time.
Okay.
So
Okay.
like I said, some banks are better about it than others, and others are not better,
Yeah.
not great about it. But
As we could say, they're a little more challenging.
yes,
But we won't name names
No
there.
naming names.
No naming names.
Not even. It sounds like this.
Yeah,
No,
yeah, we're not
we
going
wouldn't
to do
say
that one. Okay, another one I get is clients live in Pennsylvania,
Mhm.
and then they retire, and we see many of them are wandering down south.
Yes.
So do they need to get their wills updated now that they're not a resident of PA?
Now, most wills, the law of wills in most states are pretty similar. The conditions usually are, it's got to be signed and in writing and dated. There are some different rules as to how many witnesses you need. And
Okay.
some wills are what we call self-proving. where the testator signs it twice, the witnesses sign it twice in front of a notary, and that way, when you use the will later on, you don't need to produce witnesses or fill out extra paperwork.
Okay.
It's self-proving. So most states, they still work, but the power of attorney laws are very different from state to state, especially with financial powers of attorney.
Mm-hmm.
So my suggestion is if you move out of state from where you are, just take all your documents to an attorney. I have people come to me because Pennsylvania, especially Lancaster County, is a very popular retirement destination. In fact, one of the bigger ones in the country.
Okay.
And so I have a lot of people coming from out of state. Typically when I look, the wills are usually fine. Like keep your will. Because usually they're older, so they haven't had any new kids or anything like that, and so they're fine. But usually it's the powers of attorney and the living will that we
Gotcha.
update.
Yeah. So then, and then also, if they have real estate in 2 different states, how does that work?
So if you own real estate in Pennsylvania, let's say you own Pennsylvania and Virginia,
Mm-hmm.
and you pass away, but you're a resident of Pennsylvania. That means your will and your estate gets opened in Pennsylvania,
Mm-hmm.
and that's the primary estate. But Pennsylvania, the estate can't really do anything with real property located in another state. So what they do is you go down to Virginia and open an ancillary estate,
Okay.
and then the recorder of deeds office still send paperwork down to kind of help. It's like a subsidiary estate, which
Okay.
sole purpose is dealing with that real estate. So that ancillary estate will either sell the real estate and transfer the money back up to Pennsylvania, or will sometimes just gets transferred over by deed to a beneficiary or a child or something like that.
Okay. So then it also then would also depend on the state if there's inheritance tax. Can you talk a little bit about inheritance tax
So
and estate tax?
Yeah, Pennsylvania is one of the few states. There aren't many. There are just a few states that have an inheritance tax. The reason they call it an inheritance tax instead of an estate tax is with estate tax, the tax rate goes up as the size of the estate goes up. So you look at the size of the whole estate, and the tax, the percentage is based on that. With the inheritance tax, is basically is taxed at a rate that depends on what your relationship to the decedent was.
Okay.
So gifts to spouses and charitable organizations, there's no inheritance tax on it. But when you pass away and they give money to your kids or grandkids, that's 4.5%. They're called lineal descendants. And then siblings, gifts to siblings are 12%, and everybody else is taxed at 15%. This is
Wow.
a specific Pennsylvania tax based on Pennsylvania estates. And like I said, if you have property and real property in Virginia, Pennsylvania does not tax. They don't have the ability to tax
Okay.
that part of the estate. So,
Okay.
So that's how the inheritance
Interesting.
tax works.
Do you see that changing?
No.
No.
No, it's actually a fairly simple tax because there aren't that many rates. It's relatively straightforward. I don't see it changing. Just because it's a good revenue maker for Pennsylvania, which is if it went away, they would just find somewhere else to get it.
Okay.
I would think.
So our opinion doesn't matter.
Yeah, and people ask me that all the time. Like, how do I get around the inheritance tax? And my first thing is, they've thought of everything you have already. So, but really, the only way is to because what they do is they look back 1 year from anyone who passed away, and any gifts over $3,000, they just say, okay, we're going to tax that.
Okay.
Because they don't want people to find out, they're going to pass away, and then give everything away. And then so basically, what it took was the only way to get away from the inheritance tax is, you can donate everything to charity, but or you can give everything away and then live for a whole year.
Okay.
And that's really tough to do.
Yeah, that might not work in everyone's plan, their financial plan. So I think you've given us a lot of things to think about. What do I need, Matt, if I want to come in or go to any attorney? Again, there's so many great attorneys here in Lancaster County. What would I need to get a will started, or what kind of information do you need from a new client?
Basically, just an idea of what their family, if they're married, their marital situation, if they have kids, if their plan is to give everything to their kids or the surviving spouse, and also they should have an idea who they want to name as their agent. under their power of attorney or their executor under the will. And have contact information for these people is always pretty good.
Okay. And when they once they draft up something, how does it work? Do you like write it up and then they pop back in, or is things done through Zoom? How do you do these appointments these days?
Yeah, you can really I leave it up to the client. I just call them up. There's got to be an initial meeting usually, especially if it's a new client, you're starting from scratch. If it's an existing client, they're just calling to make a quick touch up to the will. I might just do it and schedule time for them to come in and sign. But typically, we do an initial meeting, where I talk about all that stuff. Usually takes like half an hour or so, depending on half an hour. Sometimes up to an hour. And then at the end of that meeting, I have all the information I need to draft documents. So then I draft them ahead of time, and then either send it to them in the mail or email. And like you said, that initial meeting can be over Zoom. It can be on the phone. It can be in person, whatever the preference of the client is. And then once they've had a chance to review the documents, the drafts, and he has asked any questions they have, whatever, then they come in and sign.
Okay.
I don't know how all attorneys do this, but our practice is, they come in and they talk, and then I'll give them a quote of the price that it will be. We don't do hourly. We just, at the end of the meeting, I'll pretty much know exactly what I'm doing, so I can put a price tag on it.
Okay.
And it's not binding. It's just at that point we agree. Okay, if I do work, it's going to cost this much. Okay, go ahead.
Okay, good. Because that's often a question we'll get to: is how do attorneys charge your fees? And I do know it varies, and it also to the depth of the work. Yeah. Your scope of work is going to determine a lot of what things cost.
Some attorneys bill everything hourly, but they should at least be able to answer you up front and give you a ballpark with the understanding. And I do, because I fall in this trap all the time, because people say ballpark. And then you tell them, it'll be between $500 and $1,000. And let's say you give them a $700 bill. What's the first thing they say? You said $500. So usually, you try and get a ballpark, but realize it's a ballpark, because if you come back to them and say, well, actually, now I need this sophisticated trust to do it.
Correct.
You're not going to be at the same quote as doing simple wills. So.
Okay. How do you sign? And this was another question on POAs. How are you supposed to sign your name? We get these different ways. Is there a standard way, or is it financial institution preference?
I mean, it could be a financial institution preference. I would do it the way they tell you. Typically, you just sign your name and then comma agent if you're serving as someone's power of attorney. Now, that's another thing I always want to say, and I catch myself doing this all the time. People will say, well, I'm power of attorney for my dad. And technically, that's not right. The power of attorney is the document, and the document names an agent. So you're your dad's agent.
Okay.
The principal. That's how that works. But I say that all the time.
Okay.
Too, so.
Okay. So you would name an agent, and it ceases upon death. Yes. We get that one all the time.
Yeah, powers of attorney. They'll say, hey, someone will pass away, and then someone will come and say, hey, I'm agent for son. They'll say, I'm POA for son. Can I do this with the account? And I'd be like, well, the accounts, technically, they're frozen at this point. The power of attorney doesn't have any effect. You got to wait till you get death certificates, and then potentially see if we have to open an estate, and then the will kick in, and they can start doing something once the estate's open if they're named the executor.
Okay. Well, I think that was most of the questions we have. Is there anything else that you're kind of pops in your mind that may come up as you were also over your many years of working with people?
Well, one of the big things is people ask us all the time, like, especially with real estate and having that passed off to their kids. People come in and say, well, I want to put my kid on the deed, because then when they pass away, it automatically goes to them as the joint owner. But there are some problems with that, especially if the kid doesn't live there or isn't going to live there, because so you see it a lot with like hunting cabins and vacation homes and things like that. But there's a problem, because when you do that, when you give something to someone during their lifetime, you transfer your basis in the property to them. Okay. So let's say you bought it for $100,000 20 years ago. Now it's worth $300,000. When you give it to them, the basis is transferred to them, so their basis is the same as yours. So even though there's all that appreciation in there and building gain, that doesn't transfer you. They get it at the same basis you have it. However, if you pass away and it's in your, through your estate, the property goes to the person, then they get what's called stepped up basis. So that's So let's say the cost basis was $100,000, fair market value is $300. That's their basis in the property. So now if they sell it, they don't get all that capital gains because it's their basis is much higher. So
I got you.
Liability gain, and that's probably one of the biggest factors, because if they don't live in the property, it's not the residence, and they can't use that $250,000 deduction, and they get hit with a capital gains tax.
Correct.
So sometimes it's better, like, lifetime gifts aren't always the best idea, just
Gotcha.
for tax purposes. So.
Correct. Yeah, and we do get that question sometimes, or being put on mother's account. Often we'll get that one too. Should I put my name? And I often will say, well, what happens if you die first?
It's the same problem. Yeah, especially if you have like 5 kids, so they put one kid on so that they can sign stuff. And what really you're putting them on as a co-signer and co-owner of the account, but they're a co-owner of the whole account. So so let's say someone dies and then all the money goes to the one kid, and say it's split amongst the other kids, and that was really the intent. So it's better just, if you name someone as your agent, they'll be able to sign checks for you. You don't have to put them on the account.
Yeah, that would make sense. Good. Well, I don't think we had any other questions, Matt, at this point that I remember or we've written down.
Oh, one other thing is people always ask about revocable living trusts, because they'll hear about it.
Okay.
In Pennsylvania, it's really not that big a deal. I mean, they'll work in Pennsylvania. And the thought is you just have a trust that gives away your property instead of having an estate. In Pennsylvania, like, probate is not that terrible as it is. You hear about nightmares in other states. And the inheritance tax applies whether it's a trust or a will. So in Pennsylvania, it's not really necessary like it is in other states, but it'll work.
Okay.
So.
Because a revocable trust means it comes back to your estate.
Well, no. So the revocable trust, when you pass away, the trust says, okay, when I die, it goes to these people, and it gets distributed just like it would have in a state. And like I said, in other states, you get a lot of advantages because you can get tax savings. You don't have to deal with probate estate. But in Pennsylvania, those advantages really aren't there because, like I said, the inheritance tax is going to apply anyway, so there's no tax savings. Probating a will in Pennsylvania, the courts don't get involved unless you ask them to. So it's not as crazy as in some other states.
Okay.
So, but like I said, they'll work. A revocable living trust will work. And at the end of the day, you still need to have a will. We call it a pour-over will that catches anything out there and puts it into the trust if it's not already in there. So you're going to need a will anyway. So why not just do a will? And you don't even need to worry about the trust. But it works in some situations.
That makes sense. Yeah, and getting a legal opinion on that would make the most sense.
Yeah.
Before you go draft the document and move assets into it.
Yeah.
Right. Okay. Anything else you can think of, Matt?
That's about it.
That's it.
Picked my brain.
We picked your brain. Yeah. Well, we sure appreciate it, Matt. Thank you so much.
Yeah, of course.
And again, if someone has questions, you can always reach out to our office, and we can put you in touch with Matt or give you opinions on other local attorneys that do similar work or same work as what Matt and his office does. But we want to thank you, Matt. Thank you very much. I really appreciate your time.
Appreciate it.
All righty.